We now have what may be a checkmate in the case of Disney versus Florida and Disney versus DeSantis, specifically in the federal case that was filed by Disney preemptively against Ron DeSantis and against the CFTOD board members. This is the case that really everybody was talking about originally, the First Amendment case, the Contracts Clause case, the due process case. And I immediately came out and said, nope, this thing is going to get thrown out. It's going to get dismissed. And I gave a bunch of reasons. Well, it looks like the district, the CFTOD, has filed a motion to dismiss, making exactly the same arguments that I made, kind of confirming that. So we're going to go through those arguments, the logic, and how this may be the checkmate of the district and Florida against Bob Iger and Disney. Of course, I'm Andrew Esquire. This is a legal mindset. We teach you to be your own judge. And of course, this is a premiere. So thank you all for joining me on this premiere, particularly as I take a little bit of a hiatus from lives over the weekend. So let's just jump right into this particular case. So this is obviously filed in the federal court for the Northern District of Florida, the Tallahassee Division. And this is the CFTOD's defendants reply in support of a motion to dismiss or abstain. So what this is the CFTOD defendants. So that is all the board members of the new district. They want this to be dismissed or they want them to abstain. So either way, this would be to either completely dismiss the case or hold off on the case until the resolution of the state case. So what they want is they want the state law to take precedent over this federal case. This is a filing in the federal case. Now remember, all of the Disney shill media, all the legal eagles, Leonard French, all those other people, they were saying, oh my God, it's such a perfect filing for Disney. It's so great. It's a shoe-in. It's a strong case. Well, this lines up exactly the logic I have told you guys about and exactly the reasoning that I believe the court will rule on and rule favorably on as to why Disney's case should be thrown out or why it should be abstained on in the federal case. So we're going to go through that today and get into the details. Of course, this will be a little longer video, but I want to get into the logic behind this. It's 42 pages. We'll skim it, but we're going to hit the highlights. So as a highlight of all the arguments, the main arguments, we're going to talk about the abstention. So a Pullman abstention, we'll talk about what that is. The form selection clause, that's a form selection clause of a contract. We're going to talk about the contracts clause claim and how that sucks and how it's horrible. The takings clause claim, how that doesn't work. Due process claim, how that doesn't work. And also the First Amendment claims, which are meritless. So let's jump right into the beef of the argument. So of course they give citations to start out, and then they just jump right into it. And they say, in this case, at the heart of this dispute, the agreements, so these agreements that Disney entered into at the last second, remember, right before the district transitioned from Reedy Creek, which was controlled by Disney, to the CFTOD, which is appointed by the state, including the legislature and Ron DeSantis, they entered into some agreements. Now, as I've said, these agreements, pretty illegal. It appears that the way that Disney did them, the way they enacted them, was very clearly illegal. So in this, they're writing, Disney confirms that the agreements at the heart of this dispute were entered to frustrate the will of the people of Florida expressed through their elected representatives about how to organize the governance of the state. Guys, at the core of all of this is exactly what I've said. This is exactly what the district is arguing. At the core of this is who governs the state. Does a corporation govern a state, or does the elected bodies, do the elected people govern a state? This deals with the delegation of government powers to a private entity. This is of utmost importance for the state, for the people of Florida, and really for case precedent everywhere. If this is allowed to happen, if governmental powers can end up in the hands of a private corporation, you have an extremely dangerous precedent on your hands here. So Disney states they were meant to secure Disney long-term certainty before RCID's dissolution and governance changes came by. It says, the Constitution, however, does not entitle Disney to a local government that functions essentially as the company's wholly owned subsidiary, nor does it grant Disney the right to undermine the state's attempt to end that corrupting agreement. So the state at every single instance has the ability to create and destroy governments. They can create and destroy cities, counties, and special districts. That is their power. They're able to do that. So nothing about the state constitution, state law would prevent them from doing that. And there's no agreement you can enter into to take away the government's power to do that. And the court noted, right? So the state case noted, and they're citing the state judge here, saying that this involves unsettled issues of state law implicating matters of state sovereignty and of great interest to its economy and citizenry. This is exactly the type of language you want to see when you're looking at a type of essentially what this Pullman abstention is essentially deferring to the state. So in most cases, when there is state law at issue, the federal case has to wait until the state law is addressed. So the state issues have to be settled first before you move on with the federal issues. So in this case, there's serious issues of state sovereignty here of great importance. This is exactly the type of thing you hold off on, and that's what's called a Pullman abstention. So that's what they're talking about, saying a Pullman abstention is warranted, which means hold off, hang out until we settle the state law issues. So it says right here, A, this case presents unsettled issues of state law. This is exactly the type of reason why you hold off on the federal case, you pause Disney's case, and you go with the district's case in state court, which, by the way, Disney is going to lose. So Disney does not want this at all. They would absolutely be hurt by this if this is dismissed, if this goes to state courts. They absolutely want to try to keep this in federal court. It helps their narrative. It helps their case to say, okay, it's purely a federal issue. But this, as the district says, and as I would concur here, is state law. Let's read what they say here. The validity of the development agreement and restrictive covenants is unsettled. Yes, because Disney does not agree that they're invalid. In fact, they're arguing that they are valid. They want them to be upheld. They're actually asking the federal court to uphold those agreements. The validity of these agreements raises questions regarding the interpretation of Florida Statute 163. So guys, when you're interpreting state statutes, that's a job for state court, not federal court. Federal court does not interpret state statutes. That's ridiculous. And frankly, any lawyer would know that. When I see these arguments, when I saw Disney making these arguments, all I'm thinking is Disney is just trying to delay. So at stake here, you have the scope of a municipality's ability to contract away legislative power under Florida law. Excuse me, guys, got a bit of a cough here. But the enforceability of restrictive covenants against Florida governmental units. So what you're seeing here is you're seeing an argument that that the legislative powers should be delegated from these governmental units to a corporation. And also, like I said from the beginning, you're seeing an issue with the enforceability of restrictive covenants against governments. So I've told you, HOA laws, HOA rules do not apply to Florida governments. So Florida governments, which, are cities, counties, things like that, they don't have to follow your HOA rules. So if the HOA says, hey, paint your fence purple, your fire department, they don't have to do that. Even if they're within that section, they do not have to follow HOA rules, restrictive covenant rules. And this is something that would really create novel law in the state of Florida. And I've said this before. I've looked into this extensively. This is my area of law. It's my specialty. And I have found no law that would allow this to ever happen. In fact, I've found very clear law that says this cannot happen. So that restrictive covenants cannot be used against Florida governmental units. And this case would actually be really amazing case law in the state court to be very clear that restrictive covenants do not apply to governments. So Disney also makes the argument that Section 163 of the Florida statute doesn't apply to the district. So they're trying to say that this 163, which gives them the ability to enter into development agreements, doesn't apply to the district. But yet at the same time, they're trying to use that to contract away the district's power. So they tried to, let me just explain this very simply. Disney tried to delegate governmental power, the ability to issue development credits, that is to give permission for what can and can't be built. They tried to send that from the district, a government, to Disney. So to assign that to Disney. Say, with the pixie dust and wave of the wand, Disney, you now have the power to assign land use rights, development rights. Now, that being said, that is absolutely something that would be completely novel, as they say. It's a completely novel argument. So they've got to settle that in state court, and they've got to prove that they can actually do that in state court. So these are clearly unsettled state law issues. And then B, the resolution of state law will materially alter nearly all of Disney's claims. So this is what I've been saying all along here, guys. So a state court ruling that the agreements are void ab initio would decide, or at least materially alter, 4 out of Disney's 5 claims. So as you see here, the agreements, if they're void, they would take out the contracts clause claim in count 1 because there's no contract. If they're void contracts, there is no contract. So count 1 goes. The takings claim, count 2, that goes because there's no property, right? Because they were trying to say that they have a property right in a contract. So that's the takings claim. That's gone. Due process claim in count 3, that's gone because there's nothing to be deprived of. There's no due process. The retaliation claim, the first of 2 First Amendment claims, that's gone because that was geared around the contracts. So they would only have count 5, just one count about the material altering, and that's it. And they've said that, hey, look, case law says when the majority of counts should be will be altered, right, by the state law ruling, you actually have to dismiss the case. You actually have to have an abstention. You have to push this over into state court. There's actually a case here which they cite where there was 9 counts and 4 of them were serious counts that were subject to the abstention. 2 counts were not. And guys, sorry about that. Kind of sick today, but I wanted to bear through this because I've got some traveling to do. So I've got to get this done. So make sure you like and comment this video because even though I'm sick here, I'm dying, I'm willing to do this because this is breaking news. And I just had to get it to you guys, even though I'm literally dying over here chugging this water. So make sure you like and subscribe to this video. If you like your boy Andrew Esquire here going hard to get this information to you and get it to you fresh here and raw from Asia. Now, this says, look, even if like 4 out of 9 counts are just serious enough and they're serious state law and they would require an abstention, that's enough to stay the entire case. So here you've got actually 4 out of 5. So that's much better than 4 out of 9. So that, based on the numbers, should be stayed, should be pushed into state court. Next, this case warrants an exercise of the court's discretion to abstain. So there's obviously times in which it's such a serious issue of state law that you need to push it into state court. This is one of them. Literally, the court said it right here. This is what the state court said in the state case. The validity of these agreements is clearly a question of great public importance. They contradict the legislature's policies toward the district, and if valid, would permit Disney to control all development rights and land use regulations in one of the most heavily visited areas in Central Florida. These issues implicate matters of the state's sovereignty and are of great interest to its economy and citizenry. So obviously, this is a big issue for Florida. It's a huge issue for Florida. It has important state functions that it implicates. So because of that, because it's so important, it should be dismissed or it should hold off, it should be paused, until the state case resolves. So this, once again, if this happens, Disney is done. This is a checkmate for Disney. They're absolutely done because they're going to get their claims invalidated in state court and they are going to lose. So that part is pretty solid there. Now they go into forum selection. Now, you guys may have seen this. Have you ever seen a contract when it says, hey, this contract will be adjudicated in Florida, or all claims will be adjudicated in Florida, or wherever else you are? Well, these contracts, these agreements, they said they're going to be dealt with in Florida. In fact, they said they're going to be dealt with in Orange County, Florida, not in federal court. So we got to deal with that. So even if you weren't going to abstain here, you would have to deal with this in state court because that's what they said they would do. If these contracts are valid contracts, well, they said they would be adjudicated in Orange County, Florida. Well, they should be in state court. So let's go with that. That's what Disney's own agreement said. Now, by the way, it's property law, so that's the proper way to do it because obviously property law is dealt with in state court. Every lawyer knows that. It's a state court issue, not an issue for federal court. All right, so going down after forum selection, they argue that the contracts claim is meritless. So obviously, if the development agreement and restrictive covenants are not valid, if they're void ab initio, void from the beginning, there's no contracts clause claim. So the argument is that they're void ab initio. They're void from the beginning. So if they're void, no contract clause claim. That's what I was saying, guys. I've been saying all these arguments from the jump, that these agreements were never valid. They were never okay. They were never good under Florida law. So under 163, these things, not good. They're bunk. Therefore, that whole first claim, just toss that out. Also, it says right here that it does not allow for this delegation of power to Disney. So it cannot, right here, they're saying these agreements effectively ceded government authority to Disney over land use throughout the district. That's illegal under Florida law. That's not constitutional. You can't give over land use authority. And that's not what even the act does, right? So under 163, you're not even allowed to do that. They're going beyond the powers of the act itself. So this is not allowed. It's illegal. It's beyond the statute. So therefore, what Disney wants to do is not enforceable, right? You can't do that. They get into the other arguments about the, which once again should be adjudicated in state court, but the arguments why the agreements are not valid. So one of those arguments is there's no valid consideration for the agreements. So a part of a contract is consideration. Whenever you give something, you need to get something in return. Well, here's the thing. For these contracts, Disney gave nothing. They wanted to get everything, and they gave the district nothing. There was nothing the district received. Therefore, those contracts were invalid. Third, and they go into this once again, that this delegation of governmental authority to a private entity violates public policy. It's against Florida law. It's against Florida public policy, and is not allowed under Florida law. Therefore, those contracts are not valid. And right here it says it's unlawful because it places a private entity in the position of a zoning authority, not only for the entity itself, but for other landowners in the district. So literally Disney says, it admits that the agreements require other landowners to obtain Disney's prior written approval for development on the land. Disney would become a government. Disney would give zoning approvals. That's ridiculous. It's supposed to be the government that does that, not Disney. So yeah, that's not going to happen. That would be massive powers that nobody else would have. Literally, think about it. Disney would be the one to approve for other businesses. Because remember, within Reedy Creek, it's not just Disney. There are other companies, other corporations within the boundaries of Reedy Creek. Now, Disney is the largest one, but there are other businesses there. So they should be going to the government for their zoning approvals. For example, when they want to build something or expand or get a permit, they should go to a government for that, not go to Disney and kowtow to Disney. That's ridiculous. So Disney also hasn't really put any law forward saying that restrictive covenants cannot bind the government. Guys, I've been saying this from day one. My basic property law class, when I teach property law, I teach property law 101. Restrictive covenants cannot bind the government. Disney hasn't put one bit of case law forward to show that restrictive covenants can bind that. And they haven't offered, like I said, a single case showing that a government can be held to enforce a private restrictive covenant. So things I've been saying from the beginning that the district is confirming here once again. If the agreements were valid, so once again, and by the way, guys, the way this is structured and all these arguments are structured is they start from the strongest argument to the weaker arguments, but also from the ones that should apply first. So obviously, the first thing they want to apply is just getting everything dismissed. But they give sub-arguments, like multiple arguments, on why each of the clauses should be, each of the claims should be tossed out. So neither the legislative declaration nor SB 1604 impaired them in violation of the contracts clause. So there's no way in which the ability to contract was violated by either the act or the declaration that they're invalid. That has nothing to do with that, with whether or not they're valid. So let's see here. Regardless, Disney also does not dispute that the legislative declaration is what it purports to be, a declaration of the district's opinion that these purported agreements were non-binding. So it was just the board's opinion. It had no legal effect on their validity. As I said in the beginning, and I've said this forever, the way that these contracts need to be voided is in court. That's what the statute says. It's what Florida law says. So if you want to void a contract, you got to go to Florida court for that. If you want to void a Florida contract, you can't just have one party say, yeah, that contract's invalid, and then it's invalid. No, the court's got to confirm that. So that's something that needs to be made within a court. Let's go to the takings clause. So these property rights are obviously, so they said they have property rights in the contracts, right, through the development rights. So their ability to develop, that was their property right, and that was taken from them. Well, you know, as I've said right now, they really haven't tried to develop anything and been turned down so far. That's one thing that just hasn't come up. But obviously, if they are invalid, if these contracts are invalid, well, there's nothing to be taken away. So that's, I think this kind of neatly rebuts the taking clause argument, because there's really not much, there's not much to be taken if those agreements are invalid in the first place. So those contract clause arguments that knock out the contracts kind of knock out this as well. They knock out the takings clause claim. So I think that's pretty much where we're going on that. Let's scroll right down here. Okay, due process. So due process claim. So the Disney recognizes that it can state a due process claim only if defendants acted, and I've said this, guys, in an arbitrary and irrational way. Guys, I said this from the beginning. A governmental action has to be arbitrary and capricious, arbitrary and irrational. Obviously, there was a rational reason for getting rid of this. Many people wanted to get rid of RCID for years. There is a lot of good reason to get rid of RCID. So obviously, those decisions for getting rid of RCID, absolutely valid, but also for invalidating these contracts. It's not arbitrary and irrational if those contracts don't follow Florida law. So the due process clause is also based on those contracts. So once again, if the contracts are invalid, they don't follow Florida law, there's nothing arbitrary and irrational about that. That's very rational. So that's just kind of cut off at the knees there. And this is here, but first, before issuing the legislative declaration, the board obtained the advice of independent outside counsel that the agreements were void under Florida law. So a lawyer said, hey, these agreements are void. By the way, guys, I said these were void. They could rely on my opinion here. Legal Mindset, your boy Legal Mindset, said that these were invalid. That's a rational enough reason. They could say, I was listening to Legal Mindset. He's an expert in this. He's done this for a decade. He thinks these are invalid. That's a rational reason, right? I'm independent. I'm not a Florida attorney. It's hardly irrational for the board to act on that advice by issuing the declaration and in initiating litigation to obtain a definitive answer to question the contract's validity. There's nothing irrational about filing a state court case to determine their validity. In fact, that's exactly what you have to do. It's exactly what you should do. All right, let's get to the juice here. The First Amendment claims. Dun, dun, dun. This is obviously the biggest thing that Disney has put out in the press. However, if you guys have been paying attention to this channel, you know that these are the weakest claims. In terms of a legal standard, these are super weak. So they go into here that in this case, the Supreme Court case Hubbard, this 11th Circuit case in Hubbard, the court rejected the Alabama Education Association, AEA's, claim that a relevant statute was enacted to retaliate against the AEA for its political speech on education policy. The First Amendment does not support the kind of claim the AEA made, a challenge to an otherwise constitutional statute based on the subjective motivations of the lawmakers that passed it. So if the statute is otherwise constitutional, the subjective motivations of the lawmakers are pretty much irrelevant in terms of a First Amendment claim. So it puts out here, Disney's First Amendment retaliation challenge the statute would fail if we are correct that the agreements were void from the beginning. So obviously, if they're void from the beginning, there can be no First Amendment retaliation. Obviously, they're invalid. So it's not about stifling their speech or whatever. They're just, the contracts are invalid. They're illegal agreements. So there's no way like voiding an illegal agreement is silencing your speech. It's doing what the law requires. Hubbard squarely controls, and Disney cannot bring a free speech challenge by claiming that lawmakers who passed it acted with a constitutionally impermissible purpose. In Hubbard, the text of a statute referenced expressive activity given its regulation of payroll deductions for organizations that engage in political activity. The 11th Circuit held the statute regulated expressive activity when, among other things, prohibited social media from removing or deprioritizing content and users, and required those companies to disseminate message they find objectionable. The statutes here do not even arguably reference expressive activity. There's no expressive speech here. See, they're trying to make this into them silencing Disney speech. All they did was say your illegal contracts are void. There's no speech here. And it's not even Disney speech. It's once again the district. It's these contracts that the district made with Disney beforehand. Disney's challenge rests wholly and exclusively on the subjective motivations of lawmakers who enacted the statutes. Therefore, Hubbard forecloses that challenge. So the law is pretty clear that this is not the type of silencing of speech. This is not Iger being MLK. This is not that sort of case that would imply First Amendment law. So this is pretty squarely on point here. I want to get to the sub point here. Okay, a state's decision to reconstitute state entities that exercise sovereign power is not an exercise of the speech clause. Guys, this is exactly what, guys, killing my throat here, but the scream, but I'm so passionate about this, and this is what I've been saying the entire time. See, I'm dying here, guys. So a state of Florida holds the power to determine who will exercise like power through government. So the government, the delegation of government power to cities, counties, special districts is the government's ability to do. They can do that when and where they want. So they're doing that. They're deciding who gets power, who doesn't get power. That's not First Amendment. That's just the government delegating its power. The rule is no more a recognition of a state's constitutional responsibility for the establishment and operation of its own government. All they are doing is delegating their own sovereignty. The speech clause, the First Amendment, does not constrain this exercise of state sovereignty. The state can do what it wants. It can create districts, destroy districts. That's its prerogative. And last, the legislative declaration did not constitute a materially adverse action against Disney. In fact, it wasn't against Disney at all. It was against RCID, really. RCID in the district. It really doesn't implicate Disney as a party. Disney is trying to push itself into this, is trying to hamstring its way into this, when really this was just dealing with the district itself. It doesn't really impact Disney's powers as a corporation. You can see here it says, in Wilson, the Supreme Court held that the College Board censure of a board member did not qualify as a material adverse action, in part because the censure was a form of speech by elected representatives. Similarly, the legislative declaration was merely a form of speech or a declaration. It has no effect other than to state the board's opinion under the principles of state of law, of Florida law, that the contracts were void. So when the legislature stated that, hey, we think the contracts are void, all it is a form of declaration. It had no legal effect. You need to go to court to have that ruled upon. So there's no speech being silenced. There's no actual punishment there. You actually have to go to court to adjudicate this. So therefore, no silencing of speech. And that is point number 3, which is really the end here, and wraps this up for the motion to dismiss. So this conclusion, it's signed by their counsel. And obviously, once again, guys, this is filed by the CFT defendant. So as you can see, guys, here, this is going to be most of the arguments I've made all along. And I think this is going to be the checkmate for Disney in their federal case. We should know in the next 30 to 60 days, get a response here. In this case, there can be a little bit of back and forth, a little bit of delay, but I do expect this to be a pretty quick response from the court. And I do expect it to be bad news for the rat. If you guys enjoyed this, despite all my coughing, being sick, and you know, just getting ready to travel, move around here, make sure you smash the like button, make sure you comment on the video, and let me know. I'll catch you all next time. Peace.